You're stopped by the police, they start asking you questions, and you freak out and you wonder, what do I do? In this video, I'm going to talk about the right to remain silent, what it means, when to invoke it, how it applies, basically everything that you need to know. My name is Madonna Hermes. I am an attorney in Michigan. I have been practicing for over 12 years, and I've done family law, I've done business law, criminal law, constitutional law, real estate law. So this channel is geared towards helping people learn their rights and learn the things that they need to know in everyday situations. And you might think like, well, I don't need to invoke the right to remain silent. I'm not a criminal. But you never know when you might want to murder your spouse and get away with it. I'm just kidding. No, but it's just good to know what your rights are, whether it applies to you or not, whether you'll ever use it or not. I just think it's good to be educated on this stuff. So the right to remain silent is a fundamental right that is enshrined in the Constitution, and more specifically in the Fifth Amendment of the Constitution. And the Fifth Amendment specifically states, no person shall be compelled in any criminal case to be a witness against himself. In other words, you have the right to refuse to answer any questions that might incriminate yourself in a criminal case. You should consider invoking your right to remain silent really in three main instances. One, when you're arrested. Two, during police questioning. And three, during a trial. And it could be that it's your trial, or it could be someone else's trial where you may be implicated in a crime. So maybe like where you're a co-defendant or a witness and you were all up in that shit, but you don't want to tell on yourself, and then you may want to invoke the right to remain silent. So let's delve into these three main areas. So during an arrest, you would want to invoke your right to remain silent. You don't want to inadvertently slip up and say something that might get you in trouble. And the second one is during a police questioning. So during a police questioning, they can ask you anything they want. They can lie to you, they can deceive you, they can promise you things that aren't true, they can confront you with false evidence. They can literally run circles around you to try to get you to say what they want you to say. So in those instances, you can refuse to talk to them and invoke your right to remain silent. And then lastly, at trial. So at trial, if it's a criminal case against you, you can invoke your right to remain silent. You don't have to testify. You don't have to defend yourself. And the fact that you don't want to defend yourself cannot be used against you either. So for example, the prosecutor can't say things like, well, if he wanted to explain his side of the story, he could, or why isn't he testifying? Why doesn't he defend himself? What does he have to hide? You can't say things like that to the jury. If a prosecutor says something like that, it's an automatic mistrial. If you decide to not testify, not defend yourself, you have that ultimate right, and no one can call that into question or make inferences that, well, maybe you're guilty and that's why you're not testifying, that's why you're not defending yourself. And in fact, during the trial or at the end of the trial, the judge will give the jury certain instructions called jury instructions, and one of those instructions specifically instructs the jury not to use someone's silence against them, not to use the fact that they decided to remain silent against them. And so the jury can't, if they go back during deliberations, they can't talk amongst themselves and say, well, why didn't this person testify? Maybe they're guilty. I mean, they could talk about it, right? But they can't actually use that as a basis. And so hopefully someone in that jury room says, hey, you can't use that as a basis for finding somebody guilty. And in fact, if it comes out that somebody did use that as a reason to find someone guilty, then the defendant can file a motion to ask for a new trial based on, the jury doing something that they're not supposed to do, not following the instructions. Now you may be thinking, and it's a natural thought, why isn't this guy testifying? What does he have to hide? It's a normal inclination to think that, right? The best way to think about this is when someone's pulled over on the side of the road, you look at them and you think, I wonder what they did, right? That's the immediate first thought. We always think that that person is guilty, and we want to understand, what did you do? Why did the cops stop you? Why did the cops suspect you of doing something? Right? That's our normal inclination. We always think that someone's guilty and they have to explain themselves. But there are many reasons why a defense attorney might advise their client it's not a good idea to testify. think for me, like the biggest reason why I would tell a defendant not to testify is because honestly, they just can't stand up to scrutiny. My husband jokes about how I, like in an argument, like I'm just like bam, 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 bam. And that's because like attorneys like will literally take the smallest thing and like ask a million questions about it and try to take it apart and, to try to find like really the truth of the matter. And we do it like it's like normal, like it's like part of who we are, right? And most people can't stand to that level of scrutiny. And then they get nervous and they start saying the wrong things, or maybe like they get frustrated and they get defensive, or they get angry, or they get annoyed, or whatever it is. And juries think that like they can look at somebody and tell whether they're guilty or innocent. Like, they put a lot of emphasis on body language and, the way you look, the way you smile, the way you blink, the way, your mouth twitches, your eye twitches, whatever it is. They put so much emphasis on these little things, thinking that it may reveal the truth of whether you're innocent or guilty. And so, when you're being questioned on the stand by a prosecutor that's just like hammering you, like, what about this? What about this? What about this? And, you get, upset, sometimes rightfully so. A jury's going to read into that, and they might think like, oh, he's guilty. That's why he's getting so defensive. He's guilty. That's why he's getting upset with the prosecutor. And so that's a huge reason why we don't think it's a good idea. Most people just can't tolerate that kind of questioning. And then the other reason is, people sometimes say stupid shit, right? Like they say something that they don't mean to say, but they say it and it can be twisted and turned into something else. And us attorneys, we're very good at that. And we don't want that. We don't want a prosecutor to kind of put words in somebody's mouth or make them say something that maybe they don't mean to say. Because ultimately it is a prosecutor's job to like run that defendant ragged and pounce on every little thing they say. After all, they think that person is guilty. Like if a person is being tried for a crime, it's because they think they're guilty, right? So the prosecutor's not gonna have any mercy on this defendant. They are just gonna hammer them until they get them to crack. So anyways, most of the time, like 99% of the time, we advise our clients to not take the stand because they're just gonna screw up. And we just don't want to take the chance. Usually the risk is far greater than the benefit. Now, ultimately, that is the decision of the defendant. Like the defense attorney can advise the defendant to remain silent and not testify, but that right solely remains with the defendant. So the defendant is the one that ultimately makes the decision. And there have been several times where a defense attorney might say, hey, it's not a good idea. I don't recommend you do this. And a defendant might say, yeah, I'm going to do this anyways. So it's, it's ultimately up to the defendant. And we're just here to provide guidance and support and strategy, but ultimately it's the defendant's choice how to whether to testify or not. Let's switch gears a little bit here. Let's talk about the Miranda warning. The Miranda warning is ubiquitous. Like everyone's heard the Miranda warning, and if you haven't, you're living under a rock. And a lot of people, I think, misunderstand what it is. So the Miranda warning is basically a warning that police officers must advise a suspect who is in custody of their right to remain silent. And you may have heard, them say something along the lines of, you have the right to remain silent. Anything you say or do can be used against you. You have the right to an attorney, yada, 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 right? That's like the standard Miranda warning that every suspect in custody ought to get. Throughout the years, throughout my practice, I've had, defendants come to me and say, hey, they didn't Mirandize me. They didn't, or give me the Miranda warning. We call it Mirandize. They didn't Mirandize me. Does this mean we can, throw our case out? Does this mean I can get a dismissal? No, that's not what that means necessarily. The Miranda warning only helps you if the police interrogate you and they don't Mirandize you. If there's no interrogation, if no one's asking you any questions, there's no need to Mirandize you. The whole point of this is to tell you you can remain silent, but if you don't say anything, like there's no questioning, then no harm, no foul, your rights were not infringed upon. Now, if they ask you questions without Mirandizing you, then potentially there's something to be done here. It doesn't mean that the case will get thrown out, but if you say something that incriminates you, we could potentially get that statement kicked out. So if the police interrogate you and you're not given a Miranda warning, we can file a motion to suppress the statements that arose from that interrogation. And if the judge is satisfied that the police did not meet their burden, did not Mirandize you, and the conditions were such that they should have Mirandized you, then the judge may throw out that statement. That means they can't use it at trial. Now take it a step further. If that is the only evidence against you and the judge throws that statement out, well then you could possibly get the case thrown out as well, because there's no evidence against you anymore. If, however, there's other evidence against you, then the case goes on without the suppressed statements, but with the other evidence. Let's say, for example, Bob commits a murder. He leaves the murder weapon behind, he leaves his DNA behind. He really didn't consult with me about how to get away with murder. I'm just joking. He leaves all this evidence behind, and then he's taken down to the station and he's interrogated without first being Mirandized, and then confesses to murder. Well then, if he files a motion to suppress, the judge might throw out those statements. The judge might say to the prosecution, hey, you can't use the fact that he admitted to murder, that he confessed to murder in the trial. However, you can still use the DNA evidence and the murder weapon to prove that this person committed that crime. Let's say, however, there is no murder weapon, no DNA, and Bob is taken down as a suspect and he is interrogated by the police. He confesses to murder. He is not first Mirandized. If he files a motion to the judge and states that the conditions were such that he should have been Mirandized and he wasn't, and the judge is convinced that the police infringed upon his Fifth Amendment right against self-incrimination, then the judge can throw out that statement. So now, no murder weapon, no DNA, no other evidence linking Bob to the murder, no confession. Bob gets away with murder. Follow me for more tips on how to get away with murder. Now let's discuss why it's crucial to understand and use your right to remain silent. Using the right to remain silent avoids self-incrimination. It's a way to safeguard your legal interests and maintain your defense. And again, it prevents prosecutors from using that right, from using your invocation against you. Then there's also the consideration of legal process fairness. This right ensures that the legal process is fair for everybody. I mean, if you think about it, the police already have a leg up. The prosecutors already have a leg up. I mean, they've got so many investigative techniques and skills and tools at their disposal. They've got investigators, they've got staff, they've got testing materials, they've got surveillance, and then the prosecutors, they've got the legal knowledge on their side and the skills and the techniques in trial. But then we also have legal assistants and other attorneys and investigators. Basically, we have so many tools in law enforcement to screw over one person. And oftentimes that one person doesn't have staff, doesn't have investigators, doesn't have forensic capabilities, doesn't have testing capabilities, DNA testing capabilities. So one person is a totally uneven battle. It's like David versus Goliath. And we really want to make it as fair as we can, where if a person wants to confess, if a person wants to talk, they at least should be given the warning. They should at least be told, like, hey, you don't have to talk to me if you don't want to. We don't want to take advantage of people who really don't have a level playing field. Now you may be thinking to yourself like, well, I mean, who the fuck cares, right? Like, they did the crime, if they tell themselves, they tell themselves. Well, that's not always the case, because there have been so many false confessions throughout history. So many times people are really taken advantage of. Maybe they're not all there mentally. Maybe they're minors. Maybe they're in shock with what happened and they're just not thinking straight. Maybe they're in the middle of a psychosis. Whatever it may be, a confession is not always valid. And in fact, we have thrown out confessions based on improper techniques used by the police at times. So, that's why we want to really tread lightly, tread carefully in these situations, because depending on the severity of the crime, you could be put away for life. So we want to make sure that people understand their rights, understand what's at stake, and know that, hey, you can talk to an attorney about this if you want to. You don't have to talk to the police officer. And this leads me to my third point, which is that you have the right to consult with an attorney. So if you are being accused of a crime, or people suspect you of committing a crime, you really want to invoke your right to remain silent, because it also comes with the right to have counsel. An attorney will help you navigate through this process, help you understand what they're charging you with, what they're accusing you of, what the elements of that crime are. There are certain things that the prosecutor has to prove in order to find you guilty of whatever crime it is. Oftentimes, if the police suspect somebody of committing a crime, they might have one or two elements out of, let's say, 3 or 4, and they're waiting for you, they're wanting you to give them the 3rd and 4th element, through your confession. And so, an attorney can help you realize, hey, the police have this and this, but they don't have this. And so they will not be able to get a conviction because they are lacking the necessary elements to convince a jury beyond a reasonable doubt that you committed this crime. So, it's really important to consult with an attorney, because they will tell you this stuff. They will advise you of your rights and will help you navigate through the process, through the system. Sometimes people think well, if I talk to the cops, maybe I can, convince them that I'm innocent. Maybe they'll let me go. No, sister, no, they're not gonna let you go. They are not your friend. They're not trying to help you. They'll tell you that in the interrogation, hey, I'm trying to help you out. I'm gonna help you. I'm gonna give you a deal. I'm gonna make this go easy on you. It's gonna be better for you if you cooperate. That's all bullshit. They can lie to you. The Supreme Court has said that police officers can lie to defendants and deceive them in order to get a confession. They can literally tell you well, so-and-so said you did this, or we have evidence that you did this, or your DNA was found at the scene of the crime. They can literally say this stuff to you. And when you're in that moment and you're scared and panicked, you might say, well, oh shit, yeah, maybe I did do something. I don't know. Sometimes people, they say things that they don't mean to say. They confess to crimes that they didn't do. It's happened before. And so, an attorney will help you navigate through that stuff so that we know, hey, this is what you did, this is what you didn't do, or this is what they're accusing you of, and this is how we get around it, or this is what the evidence shows, whatever it may be. An attorney's your friend. An attorney's not gonna hurt you. So definitely you would want to invoke your right to speak to an attorney in this situation. And specifically, you would say, I am invoking my right to speak to Madonna Hermes. And this leads me to my next point, which is how do you invoke your right to remain silent? How do you invoke your right to an attorney? So some practical tips here. The first thing to do is to be polite. It's not a battle, it's not a fight, it's not a confrontation. You don't need to get up in their face hey, I'm not gonna talk to you, bro. No, you just say, I'm invoking my right to remain silent. I'd like an attorney of my choice. That's it. Done, right? And they can't pressure you or whatever. Once you've said that, it's done. They can't ask you any more questions. And in fact, if they continue to ask you questions after that, then you could possibly get those statements thrown out. But it's important to use very clear and precise language. Don't waver. Don't be oh, I don't want to talk to you, and right? Do I have to talk to you? And no, say it very clearly, very precisely. I am invoking my right to remain silent. I would like to consult with an attorney. I am not speaking with you. Done. And after that, if they continue to ask you questions or pressure you or do anything inappropriate, you document that. Now, granted, they're going to take your shit, so you won't be able to put it into your iPhone, but try to remember as much as you can. And when you when you get your belongings back, you document it as quickly as you can. So that way your memory, your recollection can remain clear. So to wrap it up, your right to remain silent is a fundamental legal right that is enshrined in the Fifth Amendment of the Constitution. It is there for your protection. It is there for you to use it and abuse it. And so make sure you understand how to use it, when to use it, what happens if you don't use it, what happens if you do use it and they screw up, all that stuff. So, to wrap up, it's important to be clear and concise and don't say shit and talk to an attorney immediately. If you like this video, share it and subscribe, like it, do all that nice stuff. Thanks for watching.